Attorney Malskis, you have Mr. Curry. Are you doing anything other than ruling on that case?
No, I think that just remains on for trial. I know that the state wants probably another date before the trial regarding some other things.
This is county case number 20-1589, Robert Curry Jr. The state hereby Attorney Michael Buskis. Let's just make sure Mr. Curry can hear.
It's kind of cutting in and out. Is everyone else okay?
No, Judge, you're cutting in and out.
Thank you.
Well, I'm sitting in my courtroom with the courtroom wireless. Is that?
No, it's better now, Judge.
Okay. Mr. Curry, can you hear us?
Yes, I can. It was cutting in and out at first. I couldn't hear it all.
Okay, thank you. I believe Mr. Curry is appearing in the video from the.
It's cutting in and out. I can't hear it all.
Let's go off the record to figure out the audio for a second. I think it's because of the red granite feed that we're getting an echo. So I'm going to mute the red granite feed, but we might have to unmute it later when we call that case. Let's try that. Okay, we're now back on the record. Mr. Curry, can you confirm that you can hear me again?
Yes.
Okay. I'm going to recall the case. This is 20 CF 1489, State of Wisconsin versus George Robert Curry Jr. The state is here by Deputy District Attorney Mary Kerrigan-Mayers. Attorney Michael Buskis is here. Mr. Curry is appearing by video from the Brown County Jail. We're doing the hearing by video conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube. There's no one in the courtroom gallery. Attorney Buskis, what is our status here today?
Your Honor, we have not resolved the matter, so we would ask that it continue on the trial calendar. As I indicated previously, I believe that the state would like probably another date for some motions that they had filed.
If I may, Your Honor.
Yes.
Two important matters. I don't think we've received the signed stipulations from counsel on the CAC interview, so I don't believe he has the CAC interview. And I don't think he's signed on the medical records, so he doesn't have the medical records. We have filed notice of both of those with the court, and we have provided a video to the court. We would need to have a hearing on that as well if there's going to be an objection. But obviously, we aren't going to be in a position to go forward until we get those stipulations and counsel has the opportunity to have those materials.
Attorney Buskis, when do you think that can be accomplished?
Well, Your Honor, we are not going to be signing the stipulations. And that's one of the issues in terms of the lateness of the discovery. And there's several issues dealing with that. And I don't think it's fair to really basically say to the defendant that you're not going to get discovery unless you sign our stipulation.
Well, I think that the state's request is that he not be given copies of it. He can still review it. Is that correct?
And not for we haven't received it. We haven't received anything.
DGA Kerrigan-Mayers?
We would ask for a hearing date, Your Honor. I didn't know there was an objection. I hadn't personally heard back. I apologize if he did file something of an objection. I didn't see that. These materials, we do want them to be available. We just, as we know, for privacy and victim rights, want to have certain rules in place and agreements in place. So the court, if the court would be willing, now that we're hearing the objection, we need the court to rule on their admissibility in any event. Could we have a hearing date? Because just saying I object isn't going to get it done. We need the court's decision.
Attorney Buskis, I'm looking at the calendar for Thursday this week. If you can flip to that on your calendar.
Sure, let me
How about 1:30 on Thursday?
right.
date,
I've
Your
got
Honor?
a 3 o'clock hearing, 1:30 would work.
Thursday, January 28th at 1:30.
Okay.
And Your Honor, that would deal with the objections on the stipulations. Is that also going to deal with the notice and our offer of proof on the CAC interview?
Yes, I'd like to address as much as we can on that hearing.
Are there any other motions or matters we need to take up at that time, counsel?
I think that it all deals with the motions that were filed by the state. I don't think there's anything else.
Thank you. Are you objecting to the CAC interviews themselves? Oh, I suppose you have to see it
Well,
first.
Right, that's the problem, so.
Okay.
Anything additional from the state?
No, thank you.
Attorney Belskis, anything additional from your end for today?
No, Your Honor.
Then bond continues and we'll be back on Thursday.
Okay, thank you.
And then Attorney Scavara, what are we doing on your case?
I don't understand.
Judge, I'm just going to ask for a new date.
And we'll call that case. This is Brown County case number 20 CT 897, 20 CT 1273, State of Wisconsin versus Ronda Leah Brooks-Delvo. The state is here by Deputy District Attorney Mary Kerrigan-Mayers. Attorney Mark Scavara is appearing, and then Mr. Delvo, or Ms. Brooks-Delvo, I see your name. Are you able to start your video? Now we can
Right.
see.
Rhonda, you're muted.
Oh, okay. Can you hear me now?
Yes, we can hear you. Thank you.
Okay,
We're-
sorry.
We're doing the hearing by video conference because of a global, national, and local public health emergency requiring
Yes.
limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube. The courthouse is open to the public. There's no one in the courtroom gallery. Attorney Scavara, what is our status here today?
Thank you, Your Honor. I'm going to request that this be scheduled for a status of approximately 30 to 45 days. There are several other matters that I'm going to try to consolidate with these charges and essentially come to a global resolution.
How about Tuesday, March 9th at 10:30?
Tuesday, March 9th at 10:30. Yeah, I gotta write this down too.
I've got that available, Your Honor.
Tuesday, March 9th at 10:30, and that'll be by video conference, just like this. Anything additional from the state?
No, thank you.
It's at 10:30, Mark?
That is right, Rhonda. I'll call you.
Okay. All right, I appreciate it. So what do I do? Hang out and wait now?
Oh, you hang up.
Yeah,
Oh,
that's at the
okay.
end of the hearing, yes.
Um,
On continues. Thank you.
Okay. All right,
Thanks.
thank you
Good
very
job.
much. I hang up now?
Yes, you can, yes.
I don't know how. Oh, there I am. Oh, I want to see you. Oh, Lord, how do I hear? Oh, I got it. Okay. All right. Am I off?
Not yet, no. I can disconnect you.
Thank you. Appreciate you.
And then Attorney Turner, it sounds like you submitted a plea form on your case.
Yes, I submitted a plea form this morning. I did go over that with Mr. Denney, and we have a joint recommendation to resolve this morning.
Okay. This is Brown County case number 20 CM 517, State of Wisconsin versus Raymond, Major Denney. The state is here by Deputy District Attorney Mary Kerrigan-Mayers. Attorney Michael Turner is appearing. Mr. Denney is appearing by video from Red Granite Correctional Facility. We're doing the hearing by video conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube for public access. The courthouse is open to the public. There's no one in the courtroom gallery. Attorney Turner submitted a plea questionnaire and waiver of rights form. It looks like the plan would be to enter a no contest plea to misdemeanor retail theft as a repeater. Is that correct, Attorney Turner?
Yes, it is, Your Honor.
Do you know if that's count 1 or count 2?
I believe it is count 1, dismiss and reading count 2.
Okay. Is that the state's understanding of the plea agreement?
Yes, Your Honor.
And is the state in compliance with victim notification?
I'm just checking. Yes, Your Honor.
Thank you. Attorney Turner, how did you review the plea form with your client?
I had a phone call with Mr. Denney this morning and we went through the plea form, and then he authorized me to sign and submit that document on his behalf.
Okay, so you did not meet with him in person though?
I'm unable to just because he is currently incarcerated in Red Granite Correctional.
Okay, so it's related to the public health emergency. That's a factor of why you weren't able to talk to him in person?
That is correct.
Okay. It also looks like you included the elements of the offense and then properly stated the maximum penalty with the repeater enhancer. Is that correct?
That is correct.
Now I'll go to Mr. Denney. I did have to mute your feed. Are you able to unmute it on your end? Are you able to hear us? It looks like it's still muted. Okay, you might have to ask somebody, yeah.
Ron?
Unmuted now. We have you now, Miss.
They muted me and they're trying to unmute me, but it's saying unmute on my end. All right, I'm not sure if they got me yet.
We actually can hear you now. You did unmute.
Okay. All right, thank you.
If the mute your device, this sounds like there's an echo. So yeah, Mr. Denney, is that your understanding of what the plea agreement is?
Yes.
So you're intending to plead no contest to misdemeanor retail theft as a repeater?
Yes.
Do you need any additional time to do this plea form with your lawyer?
No.
Do you need any additional time to review the criminal complaint with your lawyer?
No.
We are doing this hearing by video conference because of the public health emergency. To comply with the public health guidelines, the thing to do is have as many video conferences as you can. You do have a right to be present, though, in person in the courtroom, plea and sentencing. Are you willing to waive the right to be present for a plea and sentencing? That we can continue with the video conference?
Yes.
And if it becomes necessary to speak with your lawyer privately at some point, we can accommodate that with the video conference. Understood?
Okay. Understood.
If you are not a citizen of the United States of America, you are plea of guilty or contest for the offense with which you are charged may result in deportation, the exclusion from admission to the country, or the denial of naturalization. Do you understand that?
Yes.
According to the plea form, you are 32 years old. Is that correct?
Yes.
And you do have a high school degree or an equivalent degree?
Yes.
And it sounds like you do understand English, correct?
Correct.
According to the plea form, it says you are not currently receiving treatment for mental illness or disorder. Is that correct?
Correct.
And have you had any alcohol, medications, or other drugs in the last 24 hours?
No.
Count 1 in the criminal complaint is misdemeanor retail theft as a repeater. It's a Class A misdemeanor. Because of the repeater enhancer, the maximum penalty is 2 years imprisonment or a $10,000 fine or both. Do you understand that's the maximum penalty for this offense?
Yes.
And do you understand that I don't have to go along with any plea agreement or recommendation? I sentence you up to the maximum penalty.
Yes, I understand.
And if I placed you on probation, your probation is later revoked. You have to come back to me for sentencing again after revocation. Understand I could sentence you up to the maximum penalty at that time.
Yes,
The repeater enhancer in this case is based on the state asserting that you have a conviction for possession of narcotics via felony on December 2018 in Ozaukee County. Do you agree that that is a prior felony conviction within 5 years?
yes,
The elements of this offense are, first, that you were in a merchant's store and you intentionally took and carried away movable property. The second element is that the property was merchandise held for resale by a merchant. Third, you knew that the property was merchandise held for resale by a merchant. Fourth, the merchant did not consent to you taking and carrying away movable property held for resale. And fifth, you knew that the merchandise did not consent. I'll repeat the fifth one. You knew that the merchant did not consent. And sixth, you intended to deprive the merchant permanently of possession of any portion of its price. You understand that? So the elements of retail.
yes,
The criminal complaint includes the facts that the believes are true. Do you agree that there are enough facts in the criminal complaint to support your no contest plea to retail theft, Peter?
yes,
You have the following constitutional rights: right to a trial where all 12 jurors would have to agree that you're either guilty or not guilty. Your right to remain silent, right to testify and present evidence, right to use subpoenas to require witnesses to come to court, your right to confront and examine witnesses to testify, and your right to prove that you're guilty beyond a reasonable doubt. You understand that you'd be giving up those rights and entered a no contest plea?
yes,
Are you doing this of your own free will?
yes,
Does anybody put any pressure on you or force you to make a plea?
no,
Sounds like count 2 will be dismissed or read in. When that count is dismissed, I cannot sentence you on that count. When it's read in, I can consider the conduct as a whole. Do you understand that?
yes,
And I could order you to pay restitution in this case, including for a read-in offense. Do you understand that?
yes,
Do you have any questions about anything that we discussed here today?
no,
Are all of my questions consistent with your conversations with your lawyer about the before?
yes,
Attorney Turner, are you satisfied that your client is freely, voluntarily, intelligently, and knowingly making this plea?
Yes, Your Honor.
Are you satisfied that you understand the elements and the rights that he is giving up?
Yes, I am.
That Mr. Denney, charge in 1, Mr. Retail theft as a repeater. What is your plea?
no contest,
I will accept the no contest plea. I'll find that it's been freely, voluntarily, intelligently, and knowingly made. I'll find that he understands the elements of the crime that we received here today. Facts that support the elements that are in the criminal complaint. He understands the right is giving up, which is here today. I will find him guilty of the offense or judgment of conviction and the record based on the state's motion. Count 2 will be dismissed and read in. Is that correct? DDA Ramirez?
Yes, Your Honor.
And then we'll move to sentencing at this point. What is the state's recommendation?
Thank you. It is going to be a joint recommendation as indicated. The defendant's record is as follows. In 2020, he has a felony bail jumping conviction and OWI 4th in that same year. Possession of narcotics in 2018, as well as some other possessions, methamphetamine and cocaine. On 2017, a retail theft and a possession of THC. Then in 2013, there's some traffic matters, and then a robbery in 2008. Prison was the sentence. Some ordinances, and then a fourth-degree sexual assault in 2007. parties do think that this recommendation would be sufficient in this case. He's obviously in custody. We're asking for 1 year initial confinement, 1 year extended supervision to be stayed, and him being placed on probation for 1 year, which would be consecutive to any sentence he is now serving. Conditions would be requested as no contact with Meyer, Stores, or John Shawno. I don't see a restitution request. That would be our recommendation.
Attorney Turner?
Thank you, Your Honor. This is a joint recommendation. This accepted responsibility for his actions and his work to resolve this case. He's revoked for a period of 18 months, and he does have an out date in May. He will be on extended supervision for a period of 18 months following this initial incarceration. He is currently making plans for treatment and employment when he is released in May. He has held past employment as a cook and also working in manufacturing. We believe that Mr. Denney does have ongoing treatment needs, and the additional supervision will be adequate protection for the public given the substantial sentence that he is currently serving. For those reasons, we're asking the court to adopt the joint recommendation. Thank you.
Mr. Denney, now is your opportunity to address the court.
Yeah, well, when I did these crimes, I wasn't myself at the time. I was addicted to drugs and was in a bad way with it. After that, a few months after that, I did go to treatment and seek help, and I successfully got through my treatment and went on to, I was at Jackie Ninsky Center. After that, I did continue to work, and then I got put in a halfway house for my criminal thinking and everything, but that led to me getting here to do my time here. But I do accept what the court gives me, and I am sorry for, being that person and doing what I got into. That was never somebody I ever was before. I do not plan on going back that way. I just want to be able to better myself and become, get my family back and do better in life than where I was at.
Thank you. When the court issues a sentence after protection of the public, it defends rehabilitation needs of the defendant, character of the defendant, and deterrence of others. The record in this case indicates the individual who is probably in property or their and found health pretty significant. 2020 for felony in and OWI 4 of drug theft, 2017, very significant in 2008 for robbery. There was a higher prison sentence, and then a well, and Mr. serving a prison sentence right now. It sounds like it's the Attorney Turner said. He is responsibility for the offense and charge that he
I'm sorry, Judge. You're cutting in and out. I can't really hear.
Okay, I'm gonna start over what I was saying. Then it might help if you muted your device. You able to on your own? Okay, it is muted. Are you able to hear me better now? Okay, and he's nodding his head yes. So when I issue a sentence, I have to consider the protection of the public, gravity of the offense, rehabilitative needs of the defendant, deterrence of others, and the character of the defendant, then apply the Galleon sentencing factors to those sentencing objectives. When I hear Mr. Denney's prior record with consideration of the offense he committed in this case, he seems like somebody that is committing property crimes because of a drug and alcohol addiction. He has a recent case in 2020 that's significant for felony bail jumping and felony OWI 4th. He has a history of drug possessions, a prior retail theft conviction in 2017, and then a very serious prior conviction in 2008 for robbery, where he was sentenced to prison time. Now Mr. Denney is back in the prison system. It sounds like from Attorney Turner that he's expecting to be released in May. He did take responsibility for this offense by coming in to enter a no contest plea to the charge. It sounds like he does have an employment history, and he does have a high school equivalency degree. So there are positive factors with Mr. Denney as well. When I consider all of the positive and the negative factors, I do think the joint recommendation is appropriate. I will impose and stay 2 years in the Wisconsin State prison system, bifurcated into 1 year initial confinement and 1 year of extended supervision, and then place Mr. Denney on 1 year probation consecutive to any other sentence. No contact with any Meyer store. No contact with John Shano. I'm also going to require complete disclosure of all retail establishments that Mr. Denney enters to his probation agent. So Mr. Denney, you have to keep a log of every single retail establishment you enter so that when you see the probation agent the next time, you can disclose all that information to the probation agent. And then pay the court costs during the period of probation. Anything else? Is there any credit, Attorney Turner?
I do not believe so.
Okay, then there'll be no credit on the case. Anything additional from the state?
No, thank you.
Attorney Turner, if you could review the post-conviction rights of your client, anything additional from you?
No, Your Honor, thank you.
Okay, then that's all for your case then, Mr. Denney. Thank you.
Thank you, Your Honor.
Thank you. Have a good day.
Thank you. And there are several people signing in for the 9 o'clock.
Okay. Yes. Hello. Yes.
Hello.
Oh, hello. Hi.
You have 3 cases at 7 o'clock, so if you could try to mute your device, your case is called. Sometimes *6 will act as a mute device, a mute button.
*6.
Yes, sometimes *6 will act as a mute button.
Hello.
Yeah, Richard. Richard Schreiber.
Yes. Yes, sir.
Okay, we have your lawyer, so I think we can call your case now. This is
Okay.
Brown County case number 20 CM 557, State of Wisconsin versus Richard Joseph Schreiber. The state is here by Deputy District Attorney Mary Kerrigan Mayers. Attorney Eric Wimberger is here. Mr. Schreiber is appearing by phone. We're doing the hearing by video and phone conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom, everybody's health and safety. We are live streaming on YouTube. The courthouse is open to the public. There's no one in the courtroom gallery. Attorney Wimberger, what is our status here?
Judge, I think I've taken kind of the discovery of this to its end, and we're going to need a time to do a plea, but Mr. Schreiber doesn't. I would have teed it up for today, but Mr. Schreiber doesn't have video capability, so I think we need to schedule in person.
And if I recall correctly, Friday is generally a good day for you?
Fridays and Mondays, yeah.
How about Friday, February 26th at 10:30?
I'm going to be in branch 6. The afternoon works that day, but the morning's pretty bombed.
How about 3 o'clock that afternoon?
That'll be fine.
Friday, February 26th at 3 o'clock. Did you hear that, Mr. Schreiber?
Yes. Yes, Your Honor.
Anything additional from the state?
No, thank you.
Attorney Wimberg, or anything else for today's purposes?
No, thank you.
Then bond continues. That's all on Mr. Schreiber's case. Thank you.
Thank you very much, sir.
And then we have 2 pro se cases. I do see Tabitha House. Let's call that case first. This is Brown County case number 21F07, Brown County versus Tabitha May House. The state is here by Deputy District Attorney Mary Kerrigan-Mayers. Ms. House is appearing by video without counsel. We're doing the hearing by video conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube. The courthouse is open to the public. There's no one in the courtroom gallery. This is a non-criminal forfeiture case for disorderly conduct. It looks like the alleged offense date was January 1st, 2021. And I believe this is the first hearing in front of me. And I'm Judge Bo Legion. DDA Kerrigan-Mayers, has Ms. House contacted the DA's office at all about the case?
I don't think so.
So Ms. House, your options are that you can hire your own lawyer at your own expense. Because this is a non-criminal case, you don't automatically qualify for attorney from, say, the public defender's office. So if you wanted to be represented by counsel, you'd have to hire your own lawyer. The other option is that you could continue to represent yourself, and then you can contact the DA's office to see how they'd like to resolve the case, and that you'd also have the right to a trial on the case if you wanted to do that. Did you think about those options?
Your Honor, we have sent her the offer, just so you know.
Okay. Did you receive that offer, Ms. House?
I received an offer for resolution,
Okay.
but I didn't have any contact information, so I have tried calling Aaron at the work office. I left 2 voicemails, and then I also tried emailing him, which I did print out the email for him too that I did send him.
Okay.
But I just haven't had any luck getting in contact with them.
Okay. It sounds like you'd like more time to try to make that connection. I know that prosecutors have a lot of cases, so just keep continuing to try to contact or call the main office and see if you can set up an appointment. Is this the case that I should send to pre-trials on Wednesday afternoon, DDA Kerrigan-Mayers, or not?
I would ask not. She does have the offer. We have chosen to do an ordinance rather than a criminal charge. I will send an email to Assistant DA Aaron, but I don't know that the offer is going to change, quite frankly, given how we've charged this.
Okay. I will give you time to attempt to do that, though, Ms. House. For the next hearing, how about Monday, March 8th at 9 o'clock?
Okay.
Anything additional from the state?
No, she said she sent an email, so we should have a way to contact her. I really don't like her to put her phone over the wire, so to speak.
Okay. Did you include your phone number in the email, Ms. House?
I believe so. Yeah, I believe I included that in there. Yes, I did. I left 2 numbers.
Okay, thank you. Then that's all on this case. You can hang up, Ms. House.
Thank you.
9 o'clock. Xavier Johnson. If you could unmute your device now.
I'm here.
If we can call your case. This is Brown County case number 20 CT 773, State of Wisconsin versus Xavier Tony Jamal Johnson. The state is here by Deputy District Attorney Mary Kerrigan-Mayers. Mr. Johnson is appearing by phone. We're doing the hearing by video and phone conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube for public access. The courthouse is open to the public. There's no one in the courtroom gallery. This is a misdemeanor traffic case for operating without a valid license. This looks like it's the first appearance in front of me, and I'm Judge Lee Joyce, Mr. Johnson. DDA Carrion-Monreal, has there been any contact with Mr. Johnson?
I don't believe so, Your Honor.
Well,
Okay. So, Mr. Johnson, here are your options. Are you able to hear me clearly?
yes, sir.
Okay. You can hire your own lawyer at your own expense. The benefit of that is that you can choose the lawyer that you want. You can go, if you cannot afford to hire your own lawyer, you can go to the public defender's office to see if you qualify for an appointment from their office. If you don't meet their financial criteria, then you can petition the court for a court-appointed attorney, where we would appoint an attorney for you, but you would have to repay that expense over a period of time. And then lastly, you choose to represent yourself. Have you thought about those options?
Yes, I'll just represent myself.
Okay. And you know that lawyers have specialized knowledge in these types of proceedings.
What was that?
Are you aware that lawyers have specialized knowledge in criminal cases like this?
Yes, sir.
And even though this is a traffic case, it actually is a criminal misdemeanor with a maximum penalty of 6 months imprisonment or a $500 fine or both. You understand that that is maximum penalty?
Yes, sir.
And you still want to represent yourself?
Yes, sir.
DDA Carrion-Monreal, is this a case that I should refer to Wednesday traffic pretrials?
If the court would be willing, I could tell him the offer at this time.
Okay, Mr. Johnson, do you want to hear the offer right now?
Yes, ma'am. Yes, sir.
I will find
Thank
that
you.
he's knowingly and voluntarily waiving his right to a lawyer at this time. DDA Carrion-Monreal?
Thank you, Judge. Sir, if you're able, do you know if you're able to get your license?
I don't think I'm able, but I don't think I'm able to get my license within like the next 6 months. I don't know. It's like it's kind of a struggle right now, you know.
Sure. We would request a $200 fine plus costs if he pleads today, if he wants to resolve it.
It's a $200 fine. What
Plus
was that?
costs.
Plus cost. What does that mean?
There's a I'm sorry.
Yeah, we'll look up what the total is with the court costs.
All right, so just an extra $200. So that means I won't be on signature bond anymore, or
The total is $725 with the court costs, so it is pretty significant.
so in order to pay that off, I have to pay that off cash, right?
Well, you can make payments in cash, yes. I would give you a period of time to pay that back, or set up a
Your Honor,
payment.
can I ask what $100 plus costs would be?
$599.
We'd make that recommendation if he wants to resolve it.
Mr. Johnson, were you interested in getting this case taken care of today?
Do I have to pay the $100 today?
No, I would give you a period. I would give you a payment plan.
Okay, that sounds good.
Does the state have any issue with not having a plea form going forward today?
No, thank you, though.
Okay. So, Mr. Johnson, you do have a right to be present in person for a plea and sentencing hearing. We're doing the hearing by video conference because of the public health emergency. Are you willing to waive your right to be present in the courtroom so we can continue with the video conference?
So if I don't if I don't do the video conference, I need to come in by the court by person. Those you saying? In other words?
Yes, you would have to come in person if you weren't willing to do it by phone.
I mean, I have a phone, but I just don't know how to work this Wisconsin court Zoom thing.
Okay. Well, are you able to hear me clearly?
Yeah, it's having a little static, but yes, I can hear so much.
Okay. Well, what I'm saying is that we can complete this today by phone, or we'd have to reschedule it so you can be in person in the courtroom. What would you rather do?
All right, I just got a question. If I was to come in and just sit out for my fines, how long would that be? Because I honestly don't have the money right now to just pay the fines. How does the day-by-day work for working this ticket off?
I would give you 90 days to pay a financial penalty, or you got to contact the Brown County Clerk of Court's office, set up a payment plan. Do you understand?
Yeah.
Okay. Did you want to get this taken care of today?
Yeah.
So you're willing to waive your right to be present in person so we can do the phone conference instead?
Yeah.
Okay. And I already did the waiver of right to attorney. How old are you, Mr. Johnson?
24.
And do you have a high school degree or an equivalency degree?
Yes, sir.
And it sounds like you do understand English, correct?
Yes, sir.
Have you had any alcohol, medications, or other drugs in the last 24 hours?
No, sir.
And are you presently getting treatment for mental illness or disorder? Are you presently getting treatment for mental illness or disorder? Mr. Johnson, can you kind of move to a place where we can hear you and you can hear us clearly? There's a lot of background noise, including like a beeping sound every once in a while. And we can
I'm here.
Okay, we can get this taken care of today if you find a spot where you can consistently hear me. Are you
better now?
Yes, it is, yes. Are you presently receiving treatment for mental illness or disorder?
No, sir.
The charge is misdemeanor operating without a license, 5th offense within 3 years. The maximum penalty is a 6-month jail or a $500 fine or both. Do you understand that?
Yes, sir.
And do you agree that you have 4 prior offenses for this since 2018?
Yes, sir.
And do you agree that you were operating without a valid license on March 31st, 2020?
Yes, sir.
Do you agree that the facts in the criminal complaint are accurate?
Yes, sir.
Your constitutional rights are the right to a jury trial where all 12 jurors would have to agree that you're either guilty or not guilty, the right to remain silent, the right to testify and present evidence, the right to use subpoenas, the right to cross-examine witnesses, and the right to make the state prove that you're guilty beyond a reasonable doubt. You understand that you'd be giving up those rights by entering a plea?
Yes, sir.
Are you doing this of your own free will?
Yes, sir.
Has anybody put any pressure on you or forced you to make this plea?
No, sir.
Do you have any questions about anything that we've talked about?
No, sir.
I do have to warn you that if you are not a citizen of the United States of America, you are advised that a plea of guilty or no contest for the offense with which you are charged may result in deportation, the exclusion from admission to this country, or the denial of naturalization under federal law. Do you understand that?
Yes, sir.
And to the charge in count 1, misdemeanor operating without a license, 5th offense within 3 years, what is your plea?
Guilty.
I will accept the guilty plea. I'll find that it's been freely, voluntarily, intelligently, and knowingly made, that he understands the facts and the rights that he is giving up. And then what is this? I will find him guilty of the offense after accepting the guilty plea and order judgment of conviction entered into the record. And what is the state's recommendation?
Thank you. I don't know of any other record, but obviously with costs, even $100 fine, it does add up. It is a 5th, so we're going to ask for a $100 fine plus cost.
Mr. Johnson, any comment on sentencing?
No, sir.
Then I will sentence you to a $100 fine plus court costs for a total of $599. When I review the sentencing objectives and the galleon factors, I do believe that a significant financial penalty is a sufficient deterrent to prevent Mr. Johnson from operating without a valid license in the future. I'll give you 90 days to pay that or set up a payment plan with the clerk of court's office. So if it gets to 90 days, Mr. Johnson, don't just ignore it. Make sure you contact the court's office to set up a payment plan. Understood?
Yes, sir. Can I get more than 90 days? Because I don't think I'll be able to have it paid by 90 days. Honestly.
Okay. Well, then you have to contact the clerk of court's office to set up the payment plan. Then that's all you have to do.
All right.
Okay.
All right.
Anything additional from the state?
No, Your Honor. Thank you.
You'll be mailed this information, and you will be mailed the information on how to make payments. Okay. Okay, Mr. Johnson.
That sounds good.
Okay, and then that's all in your case. You can hang up. Thank you.
All right. Thank you. Hey, one more question.
Yes.
So I'm not on signature bond anymore. Is that correct, or how does that work?
That is correct. The signature bond goes away when you entered the plea. And
All right. Okay. All right. Thank you.
And that's all for today. Thank you.
All right. Thank you.
And then I think we have about a 10-minute break here now.
Thank you. Did you get to the game yesterday, Judge?
No, I didn't.
Sad day.
Yeah, very, very disappointing. But they seem to have a team that's built to be just as good the next couple of years. So
Sounds good.
I'm optimistic.
Okay, see you in a bit.
She still got your confidence. Okay, at least you still got your confidence.
But like I'm a fall. I thought I'm fall.
We have nothing until 9:30 now. If you could mute your device, and then we won't be able to hear you. You can mute.
Okay.
Who was that?
That's
People
somebody.
that's in court now.
That's like they scream.
There are 3 cases scheduled for 9:30. Attorney Putstuck, who do you have? I don't see your name on the calendar.
Morning, Judge. I'm on 20 CF 1638 for Megan Carollo this morning.
Okay, I see. Okay. Do we have Ricardo Carrion-Monreal?
Yes, Your Honor, I'm here.
Okay. It is 9:30, so we can call that case right now. This is Brown County case number 20 CF 1638, State of Wisconsin versus Ricardo de Jesus Carrion-Monreal. The state is here by Deputy District Attorney Mary Kerrigan-Mayers. Attorney Joe Putstuck is here. Mr. Carrion-Monreal is appearing by video. We're doing the hearing by video conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube for public access. The courthouse is open to the public. There's no one in the courtroom gallery. We are on the calendar for an arraignment. Attorney Putstuck, are we ready to proceed on the arraignment?
Yes, Your Honor. Thanks.
Mr. Carrion-Monreal, you do have a right to be present in person in the courtroom for this hearing. We're doing the hearings by video conference because of the public health emergency. Are you willing to waive your right to be present in the courtroom so we can continue with this video conference instead?
Yes, sir. Yes, Your Honor.
If it becomes necessary to speak with your lawyer at some point, we can accommodate that with this video conference procedure. Attorney Putstuck, have you received a copy of the information?
I have, Your Honor, and acknowledge a review with the defendant with an understanding of charges and maximum penalties as well. And so we'd waive that formal reading this morning.
And then did you enter a plea? I don't know if I heard that or not.
I did not say anything. I didn't know if it was at this point, but we'd enter not guilty pleas for this morning as well.
Okay, excellent.
And then if we can set it on for a status, that'd be ideal.
I'll enter the not guilty plea into the record. And then for scheduling, how about Monday, March 8th at 3:30 for a status conference?
Again?
Monday, March 8th at 3:30.
That will work.
Mr. Carrion-Monreal, did you hear that date and time?
March 8th, if I was correct,
Yes.
at 3:30
Yes.
p.m. Okay, I got it written down.
Anything additional from the state?
No, thank you.
Then bond continues, and that's all for today. Thank you.
Perfect.
Thank
Thanks,
you.
everybody.
Thank you. And then Attorney Richmond, do we have you?
Yes, Your Honor.
Are you with your client or not?
No, he may be on iPad. I'm not sure who that is. I just spoke to him a couple minutes prior to coming on the record or coming into the Zoom meeting.
Cornelius Butler,
Yes.
are you able to turn your video on? It sent an indicator to start the iPad.
We have a little difficulties right now.
There should be an icon that looks like a camera. Okay, we can see it. It's Brown County case number 20 CF 794, State of Wisconsin versus Cornelius Dwayne Butler Sr. The state is here by Deputy District Attorney Mary Kerrigan-Mayers. Attorney Heather Richmond is here. Mr. Butler is appearing by video. We're doing the hearing by video and phone, by video conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube. There is no one in the courtroom gallery. Attorney Richmond, what is our status here today?
Thank you, Your Honor. I would be asking for another status conference. I have not had the ability to meet with my client. He was just very recently released from the hospital again. He's receiving dialysis multiple times a day. There's issues with getting new breathing equipment. He's got no strength in his legs. It's impossible at this point to meet with him due to his significant health condition.
How about Tuesday, March 9th at 10:30?
I have a jury trial scheduled that day.
What if we do it the day earlier on March 8th?
It appears that I must have 2 trials going that week because I have morning voir dire and it looks like afternoon.
How about Friday, March 12th at 2:30?
Cornelius, does that work in your calendar?
I have Monday, Wednesday, Friday are dialysis days, and those are 5-hour appointments. So this starts at 12:30, and I won't be done until 5:30.
Your Honor, does the court have something on a Tuesday or Wednesday? My guess would be a dialysis day is probably not a great day to have Mr. Cornelius up here.
How about Tuesday, March 23rd at 2:30?
Okay.
I can do that.
Tuesday, March 23rd at 2:30. Any comment from the state on anything?
No, thank you.
Then bond continues, and that's all for today. Thank you.
Thank you. You can hang up, Mr. Cornelius.
Tanner Innard? Tanner Innard?
Yes, sir.
How do you pronounce your last name?
Innard.
Innard, okay. I'm the judge on your case, Judge Bo Lee Joyce, and we'll call your case right now. This is Brown County case number 20 CT 490, State of Wisconsin versus Tanner Jacob Innard. The state is here by Deputy District Attorney Mary Kerrigan Mayers. Mr. Innard is appearing by telephone. We're doing the hearing by video and phone conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube. There is no one in the courtroom gallery. The charge in this case is operating a motor vehicle while revoked. First offense. It is a traffic offense, but it is a criminal misdemeanor offense. The maximum penalty is 1 year in the Brown County Jail or a $2,500 fine or both as the maximum penalty. Mr. Innard, I think this is your first appearance in front of me. I think you've been in front of the court commissioners before this. So you
Yes, Your Honor.
You can be represented by a lawyer on this case. The first option is to hire a lawyer at your own expense. The benefit of that is you can pick the lawyer that you want to represent you. If you can't afford to hire your own lawyer, you can go to the public defender's office and see if you qualify for an attorney appointment from them based on your financial circumstances. If you do not meet their financial criteria, then you can apply for the court to appoint you a lawyer. The county would pay that expense up front, but then you would have to repay the county over a reasonable period of time. And then the fourth and final option is that you can represent yourself if you choose to do that. Have you thought about those options, Mr. Innard?
Yes, I have, Your Honor. I did try to contact the public defender, and I was told that I did not qualify with my income. And then I did talk to an attorney over the phone, and he did say that I may not actually need an attorney. So I think I may proceed with just representing myself.
Okay, so just based on what I heard, you went to the public defender's office and you did not qualify for their criteria, is that correct?
Yes, Your Honor.
And then you did talk to a lawyer that you were interested in hiring at your own expense and you're deciding not to do that?
Yes, Your Honor. After consulting with an attorney on my own time, I was able to, I guess, come to the conclusion that I may not necessarily need one.
Okay. If you, and you know that lawyers have specialized knowledge in these types of proceedings?
Yes, Your Honor. You had mentioned that I could apply for what was that third option that you had stated?
A court-appointed attorney. That's where the court, I would appoint you a lawyer. You wouldn't get to pick who that lawyer is. I would appoint you one. And then the county pays the upfront cost, but then you do have to repay the county over a reasonable period of time.
Okay. I may be open to that option. I feel as though I'd be at a very distinct disadvantage if I represented myself.
Okay. You do have to make an option, a decision pretty quickly though, Mr. Innard. The case has been pending since April. Have you received an offer from the state? Don't tell me what it is. I'm just asking if you received it.
No, I have not, Your Honor, no.
Okay. How does the state want to get him a copy of the offer? That might help him.
I guess he hasn't really waived his attorney, so I don't know that I'd be comfortable. If he's gonna have an attorney, the attorney can do traffic pretrials with us. Otherwise.
The offer frequently is attached to the complaint though, right? When a defendant receives it?
That's been my understanding, correct.
So I'm just saying if he was sent a copy of the offer, that might help him make his decision on whether he wants a lawyer or not, without actually communicating with the DA's office.
Sure. Could he tell us, did he have an offer attached to the complaint?
Do you have a copy of the criminal complaint, Mr. Innard, with you?
I do believe I do.
Because sometimes the offer is the last page on that document.
It might have been formulated later, Your Honor. He might not have it.
Okay.
I do not think I have that. No, I have it right in front of me.
The address that we have for you is 1771 Wedgwood Drive. Is that still your best mailing address?
That is correct, Your Honor, yes.
Okay. I'm going to schedule this for Tuesday, March 9th at 10:30.
Okay.
Tuesday, March 9th at 10:30. You heard that, Mr. Innard?
Yes, Your Honor.
And when you come back on that date, you do have to make a decision on whether you're going to represent yourself, hire your own lawyer, or apply for a court-appointed lawyer.
Okay, I understand.
And the DA's office may send you a copy of the offer, or they might not. It's up to them.
Thank you. I would like to. I just think it's a little bit of awkward situation. If he decides he doesn't want an attorney, I can tell him the offer. I understand he wants to look into that option, so that's a concern.
Mm-hmm.
Thank you. I appreciate that.
Okay, so when you come back on March 9th, we do need a definitive decision from you then, Mr. Innard, on the lawyer issue, okay?
Thank you very much, Your Honor.
Okay, and then that's all in this case. Thank you.
Thank you.
And then we have nothing until 10 o'clock.
Thank you.
We have cases at 10 o'clock. Dominic Dowdy.
Yes, Your Honor, could we just have a couple of minutes in the breakout room? We spoke this morning, but the call got cut off.
Okay.
We in the breakout room right now? No, he just talked to one. He just
Jordan Lysgang. Jordan Lysgang.
Your Honor, that's my client. I don't believe he'll be on the call today. My understanding from a January 4th email I had was that based on my client getting his license back, that the state would be dismissing his case.
Okay. Well, let's confirm that that's true before we call it.
That's true.
Then we'll call the case. This is 20 CT 1296, State of Wisconsin versus Jordan Robert Lysgang. The state is here by Deputy District Attorney Mary Carrion-Monreal. Attorney Peter Kraft is here. We're doing the hearing by video conference. DDA Carrion-Monreal, what is the status of this case?
Thank you. I appreciate counsel sent proof of the driving license. We would ask this case be dismissed.
Then based on the state's motion, the case will be dismissed at this point. Anything additional, Attorney Kraft?
Nope, no objection from us, obviously. Have a great day, everyone.
You too.
Okay.
Thank you.
And that's all in this case. Thank you. And then we just have Mr. Dowdy's case. So we'll wait for them to come back from the breakout room.
Okay.
I closed the breakout room, but it does give like a 60-second countdown, and it looks like we have him now. Okay.
There we go. Thank you for that, Your Honor.
This is Brown County case numbers 20 CF 1630, 20 CM 1367, State of Wisconsin versus Dominic LaSalle Dowdy. The state is here by Deputy District Attorney Mary Kerrigan-Mayers. Attorney David Hassel is here by video. Dominic Dowdy is here by video from the Brown County Jail. We're doing the hearing by video conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube for public access. The courthouse is open to the public. There's no one in the courtroom gallery. Attorney Hassel, are we ready to proceed on the arraignment today?
We are, Your Honor.
And Mr. Dowdy, you do have the right to be present in person in the courtroom for an arraignment. We're doing the hearing by video conference to comply with all the public health guidelines. Are you willing to waive your right to be present in person so we can continue with this video conference appearance? We actually did not hear that. It looked like you said yes, but we can't hear you.
Yes, Your Honor.
Okay, so you are willing to waive your right to be present in person?
Yes, Your Honor.
Okay. And before we went on the record, we did give you the opportunity to speak privately with your lawyer in a breakout room, and we can accommodate that again if it becomes necessary. Attorney Hassel, have you received a copy of the information?
I have, Your Honor. I've reviewed it with my client along with the maximum penalties for counts 1 and 2, which are the felony counts, as well as count 3, the disorderly conduct. He understands that the maximum penalties involved and is entering a plea of not guilty at this time.
Is he waiving reading of the information as well?
Yes, we'll waive a formal reading. Thank you.
Thank you. We'll enter the not guilty plea into the record. We can schedule for a status conference on Tuesday, March 9th at 11 o'clock, unless one of the parties proposes a different type of scheduling.
Bear with me, Your Honor. I moved offices over the weekend and all my monitors are in a different place now. March 9th.
March 9th, 11 o'clock.
That's fine for the defense.
March 9th at 11 o'clock. Mr. Dowdy, did you hear that?
Sir.
Anything additional from the state?
No, Your Honor.
We do need an updated mailing address for Mr. Dowdy if you're not in custody. Do you have a consistent mailing address, Mr. Dowdy?
125 Sportsman Road.
125 Sportsman Road.
Yes, sir.
Do you know the zip code?
No, sir. It's Wild Rose, Wisconsin.
Oh, it's in Wild Rose, Wisconsin?
Yes, sir.
Okay, do you know the zip code?
I think it's 542. I don't know it. I got it.
I'm getting it, Your Honor.
Okay. And that's the place where you would be able to most consistently receive mail?
Yes, sir.
Okay.
It's 54984, Your Honor.
Okay, thank you. Then bond continues, and that's all for today. Thank you.
Thank you, Your Honor.
And then there's nothing until 10:30 now.
Thank you.
Five cases scheduled at 10:30.
Hello. Hello.
We have 5 cases scheduled at 10:30. If you could please mute your device until your case is called. Sometimes *6 will act as a mute device, as a mute button. *6 will act as a mute button if you're calling in on a telephone. Do we have Attorney Kane? Are you here?
Yes, Your Honor.
Are we doing anything other than scheduling on your case?
No.
Okay, let's call that one first because they're in custody. This is Brown County case number 20 CF 558, 20 CF 1235, 20 CF 1573. They're all state of Wisconsin versus Nicole Beatrice Smith. The state is here by Deputy District Attorney Mary Kerrigan Mayers. Attorney Brian Kane is here. Ms. Smith is appearing by video from the Work Release Center. We are doing the hearing by video conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube for public access. The courthouse is open to the public. There's no one in the courtroom gallery. Attorney Kane, what is our status here today?
Judge, the cases are not resolved. We're still working on a global resolution with the state, and we are going to be turning in a treatment court referral form as well for Ms. Smith. So we're just looking for some more time, maybe say 30 to 45 days or so.
How about Tuesday, March 9th at 2:30?
Judge, it looks like I have something that whole afternoon. I do have the morning open.
How about 10:30?
That should be fine.
Tuesday, March 9th at 10:30. Ms. Smith, can you just unmute your device and confirm you heard the date and time?
Yes, Your Honor.
Anything additional from the state?
No, thank you.
Continues, it's all for. Thank you.
Thank you, Your Honor.
Do we have to call Red Granite or are they? Oh yeah, that's right. They called it on their own this morning. Yeah. Okay. Attorney Flanagan, Red Granite called in on their own this morning, and they haven't called in on your case yet. So we're going to try to put in the number ourselves.
Okay.
Yeah, now it's just an empty room. Is there anybody at Red Granite? Anybody at Red Granite Correctional? This is Judge Lee Joyce in Brown County. Is there anybody at Red Granite Correctional? Okay, well, we'll call the other cases and then we'll have them over there ourselves. Chad Moss. Chad Moss. Jodi Satello. Jodi Satello.
My phone.
You think it's the person on the phone?
Yes, ending in
6312.
Well, we might have just lost them. I think they disconnected, so see if they call back in.
Okay, thank you.
Attorney Brabazon, then I think we go to your client, Hensley Towell. Are they with you?
He is.
Okay, call that one then. Trumbull County case number 20 CF 930, State of Wisconsin versus Hensley Thomas Towell. The state is here by Deputy District Attorney Mary Kerrigan-Mayers. Attorney Shane Brabazon is here. Mr. Towell is appearing on the same video feed as Attorney Brabazon. And can you flip your camera so we can see? Okay, and now we can see him. Thank you. We're doing the hearing by video conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube. There's no one in the courtroom gallery. Attorney Brabazon, what is our status here today?
Your Honor, the case is not resolved. We're still doing some discovery. I think I received some additional discovery from the state just a couple weeks ago. I would ask that this matter be placed for another status conference in perhaps 60 days.
How about Tuesday, March 9th at 2:30?
I'm gone that week, Judge.
Tuesday, March 23rd at 11 o'clock.
Tuesday, March 23rd at 11 o'clock is fine.
And can your client confirm the date and time?
He's asking if you can say if you received that. Yes.
Thank you. Any additional comment from the state?
No, thank you.
Then bond continues, and that's all for today. Thank you.
Thank you.
Chad Moss. Attorney Giacone, are you with your client perhaps? Okay. Well, I think we'll try calling over to Red Granite then. See where Mr. Rainey is. Attorney Jansen, if you can try calling your client. It doesn't look like she's in the waiting room or anything.
Okay, she just told me that she was, so I'll call her back, I guess, and try to figure out what's going on.
Otherwise, we can try calling her too in a minute here, if that still fails.
That might be a better idea, if we can do that. I'll tell her to hang up and that we can call her back.
Okay.
Thank you.
We're on hold with Red Granite right now for Attorney Flanagan's client. Okay, we now have 2 empty rooms at Red Granite. So we'll just wait for them to go get him. Attorney Jansen, should we try calling your client? Can you say the phone number?
Yes, 920-501-6312.
I think we should have her momentarily.
Okay.
Yeah, I think her phone disconnected again. We'll try calling her again this time.
Okay, thank you.
We have her on speakerphone in the courtroom. Attorney Jansen, are we doing anything other than getting another date on the case?
No, we are not.
She can hear me fine. I don't know if she can hear everybody else, but I'll confirm that she hears what the new date is.
Okay.
This is Brown County case number 20 CM 664, State of Wisconsin versus Jodi L. Satello. The state is here by Deputy District Attorney Mary Kerrigan-Mayers. Attorney Abby Jansen is here, and Ms. Satello is appearing by phone. We're doing the hearing by video and phone conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube. There is no one in the courtroom gallery. Attorney Jansen, what is our status here today?
Thank you, Your Honor. We have received discovery and an offer, and at this time, we are just asking that the court schedule a plea and sentencing date.
How about Friday, March 12th at 10 o'clock?
I have a hearing at 9:30. Do you have anything a little bit later, just in case that runs late?
How about 11 o'clock?
Yes, that'll work.
Friday, March 12th at 11 o'clock. Did you hear that date and time, Ms. Satello? And she said that she did hear the date and time. That will also be by the same video conference procedure. DDA Kerrigan-Mayers, anything additional from the state?
No, thank you.
Then bond continues, and that's all for today on this case. Thank you.
Thank you.
Chad Moss, or Attorney Giacone?
Good morning, Your Honor. This is Attorney Sarah Melker on behalf of Attorney Giacone. He's tied up in another branch right now, so
okay.
I'm here on behalf of Mr. Moss this morning.
Is he with you? Mr.
Yes,
Moss?
if you maybe have one other matter you could call and I can get him. He's in our waiting area.
Okay. Well,
Thank you.
we do have another case, but it's not ready to go because it's that red granite. They haven't brought him out yet.
Oh, sure, certainly. Come on. Yep, he's right here. Thank you, Your Honor.
Okay. This is Brown County case number 20 CF 711, State of Wisconsin versus Chad Jason Moss. The state is here by Deputy District Attorney Mary Kerrigan-Mayers. Attorney Sarah Melchor is appearing on behalf of Attorney Jevin Giacone. Mr. Moss is appearing on video with Attorney Melchor. They're sitting next to each other on the same video feed. We're doing the hearing by video conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube for public access. The courthouse is open to the public. There's no one in the courtroom gallery. This is on the calendar for a status conference, and I believe a motion to modify a no contact order. Is that correct, Attorney Melchor?
Yes, Your Honor, that is correct. And I believe a written motion has been filed dated January 2nd, detailing the reasons for this request, Your Honor.
Has the state received a copy of it?
We were aware it was on. I think the victim's mother may also be trying to appear, if we could check on that.
The victim's mother is actually here and they're all here is my understanding, so we could bring them over if you would like.
Okay, and I assume they're all separated? They've been separated? at the
Yes, oh yes, everybody's in separate rooms, correct, Your Honor.
What can you summarize what the request is here today, Attorney Melchor?
Certainly. We are asking that the no contact order be lifted in this matter as is outlined in the written motion.
Just completely lifted?
Yes, Your Honor. I mean, obviously with any other requirement, nonviolent contact, things of that nature. But yes, we are asking that it be lifted.
And just to clarify, if I did lift the no contact, would they all be living together then?
Yes.
Did the state want to make comments first or hear from the victim first?
I would ask if we could hear from the victim first. Thank you.
Okay, so Mr. Moss could, I guess he is allowed to be here to hear their comments. If he could just move to a different part of the room then, I guess.
Certainly, right. I could bring them into a different part of the office even. We've got, a kitchen and separate areas that we've been keeping everybody apart leading up to this request. So we'll bring the victim in right now and have Mr. Moss aside.
Okay. Okay, it looks like there's a no contact with WCM and WJM. And if we could continue to use initials instead of full names, that'd be appreciated. Does somebody want to tell me which one is the child and which one is the parent of the two? It is more difficult to follow along with using initials than full names. Although they both look like their children, is that correct? Deputy Carrion-Monreal, just based on the birth dates?
I don't have the complaint up, Your Honor. WCM is definitely a juvenile.
And then WJM is the other.
That's my twin. So,
Okay, so you're twins. So you both are juveniles.
Your Honor, we're on live on YouTube with a juvenile appearing. Can we do something about that?
Well, why don't you step off away from the camera for a second? Should we, I guess, what is the state suggesting then?
I apologize. It's obviously very awkward. I certainly have no problem. They need to have input. They need to be allowed to hear what's going on as well. I just don't think showing them is a good idea.
Okay. Well, I know if we were in the courtroom, they would be in public for everybody who's in the courtroom. But I think a good way of handling this with respect to that issue would just be for the victim to continue appearing without his face being on the camera. So yeah, if you just move the chair over, we want to make sure we can hear him.
like this?
Yeah, that's good. We can see your shoulder. We can't see your face. That's good. Yes. Can you identify yourself with your initials? Can you say it louder?
WCM.
Okay. It was WCM. However, if he's going to give a statement, I don't know if we're going to be able to hear it. Can the microphone get closer to him without moving the camera?
Well, can't they turn the video off for a moment?
Right, and if you lean toward here, maybe does that sound a little better, Your Honor?
Say testing, testing, testing. Yeah, we can't hear it. Are you able to just turn the video camera off?
Oh, sure, certainly, I could do that.
And then you can sit right in front of the microphone.
Oh, right. All right, can you hear us?
Yes, I can hear you fine. The video camera is off. WCM, can you say testing, testing, testing?
Testing, testing, testing.
Okay, now we can hear you nice.
All right.
And right now, there's a no contact in place between you and Chad Moss. And is that your father? Is that correct?
Yes, sir.
And that's because there is a charge of there's a Class H felony and a Class C felony, or no, a Class H felony and a Class B misdemeanor
Yes,
that are
charged.
pending in this case, where you're the alleged victim of count 1. And were you interested in having the no contact order lifted?
Yes, sir.
And are you fearful of your father going forward if I did lift you no contact?
No, not at all.
If there was an incident that took place in the future where you were afraid, or would you call the police?
Yes, 110%.
Okay, so you're not afraid to call the police.
No, sir.
DDA Carrion-Monreal, would you like to take over at this point if you have any questions or comments to make?
We would have comments for the court. I wouldn't have questions.
Okay. And if I lifted the no contact order, that means your father would be able to have contact with you however he wants. Do you understand that?
Yes, sir.
And that means that he would be able to live with you again.
Yep.
That would be
That's what I was hoping for.
okay. That is what you're hoping for?
Yeah.
Okay. I may have a qualification on it that he's not allowed to talk about the actual incident with you. Do you understand that?
Yes, sir.
So the incident was on April 22nd, 2020. If he started talking about the incident with you, he would be violating his conditions of the bond. Do you understand?
Yes, sir.
Okay. DDA Carrion-Monreal, any additional comment?
Well, yes, as to the issue itself,
Okay, then you can continue with your comment then.
thank you. What concerns the state is this person was the victim in a prior case, 17 CF 857, which was amended from a physical abuse of a child, was a battery conviction and disorderly conduct. He was put on probation for 2 years. In these allegations, there's drinking involved, which the defendant admits. I think he minimizes clearly by saying he poked the victim in the chin. There's video evidence, so there's a strength of case and concern with the history. Bruising resulted. It sounds like, quite frankly, that the juveniles were frankly verbally out of line, but what took place was way over the top with physical injuries taking place. I think it puts them in a very awkward situation. I don't know if there's any adult really who would step in for them. It sounds like both parents are fairly much aligned against them when this all took place. The history is what concerns us. If we didn't have the prior conviction, it would be, I think, a much different scenario. I don't mean to make it difficult for the victim, and we do wish to appreciate and honor their wishes, but we do have concerns about their safety and concerns about the case itself. Without even making comments, there's certainly pressures that can take place with divided loyalties and so forth. So I know they can have counseling right now, and I think given that we aren't even set for trial and we could be quite a ways down the road from a resolution, we would oppose at this point in time.
And what was the prior record again? Could you detail that for me?
Yes, thank you. That would be Brown County Case 17 CF 857. It started as a physical abuse of a child with the same victim. It became a battery and disorderly conduct conviction. And the other person's initials is as indicated, the brother who was a witness to what took place. And they indicated that when he drinks, he becomes violent. I just don't think we can guarantee their safety.
Attorney Malcor, would you like
Yes,
to make
thank you, Your Honor. I would very much like to. As our victim just advised me, his father is not drinking. Obviously, that's one of his bond conditions, so he is abiding by that. He went to the Golden House. He is aware of the resources that are available to him in this situation. And I think the court did a good colloquy in determining that he knows that he needs to call the cops if something like this arises again. And he's sitting right next to me agreeing. Family needs.
You faded out. The last sentence. I'm sorry.
Oh, sorry about that. I guess in summary, Your Honor, WCM is aware of the resources that are available to him and knows how to keep himself safe. And this family needs to heal. And I think that counseling is certainly in their future. And I would urge the court to consider lifting the no contact and perhaps order a condition that counseling be ongoing as this case is pending, because this is a family that needs to be put back together, frankly. Thank you, Your Honor.
Your Honor, if I may, I think one of our concerns is we didn't see anything from Golden House. We were told that that took place, but okay, so they do have it. Our prosecutor looked. The other concern is WJM. Where does that leave him? I don't know. Is he also physically in the office as well? Because there was no contact with both of them, and he's kind of got the same pressures as a witness and endangerment issues. Thank you.
Okay, I'm actually going to deny the request. If there wasn't the prior case that involved this same victim, which kind of sounds like it's similar circumstance based on what the state's describing, I would be more apt to entertain lifting the no contact while the case is pending. We have made exceptions already to the no contact, it looks like, for the attending the counseling sessions together. So there is already an exception to the no contact order. And I think that that's the only appropriate exception while this case is pending. So I am going to deny the request to lift the no contact substantially because of the prior incident that seems rather similar. And although the charge was amended from the felony charge, there was a conviction for battery and disorderly conduct in that case. And then how would you like to schedule an Attorney Malcor? If we scheduled for a status conference, the March 8th or March 9th, otherwise we could schedule for trial if Attorney Ciccone would prefer that.
I would be interested in scheduling for a status conference, Your Honor. What was the date that you would?
Let me just make sure your client is back. Your client can hear.
Sure. Give me a moment so I can have the victim leave the area and I'll bring Mr. Moss back.
Yes, thank you.
Right. Here's Mr. Moss, Your Honor.
Okay, thank you. Tuesday, March 9th at 2:30. Tuesday, March 9th at 2:30. If you responded, we didn't hear you.
I'm sorry, can you hear me?
Now we can, yes.
Oh, okay. Sorry, I just wanted to verify that 2:30 on March 9th is in fact for a status.
I think you're not speaking into the microphone. You have to I know Attorney Ciccone knows how to use his device. He has to look right into the middle of the screen, basically, from our angle.
Sure. Is a status at 2:30 on March 9th. Thank you, Your Honor.
Okay, so you heard March 9th at 2:30?
Yes.
Okay, and your client heard that as well?
Yes. Yep, he's right here.
Okay, anything additional from the state? Oh, you
got her moved on.
Anything additional from the state? You were muted if you responded.
Oh, I apologize. I did. I know it's difficult for counsel shuffling the people. Could she check with other persons who are in the victim category, the mother and a juvenile, to see if that date's okay with them? I would trust her word if she just does that quickly.
Certainly, I can definitely do that. Yes, Your Honor, and Attorney They indicated that was fine with them.
Thank you.
Okay, thank you. Then bond continues, and that's all for today. Thank you.
Thank you.
And then we can go to Mr. Rainey's case. Are you Jarvis Rainey? Are you Jarvis Rainey? Who's the individual at Red Granite Correctional?
That is Jarvis.
It
I don't
is?
know if it's mute, but that is Jarvis. At least it appears to be.
Mr. Rainey, are you able to hear us? We cannot hear you if you're responding. Rainey, maybe the device is on your end. Can you give us a thumbs up if you can hear us? Okay, you can hear us. Okay. Then the device is muted. You're able to ask staff there how to unmute it. There was remote control that a gentleman was using earlier. Do you see remote control? Someone picked up nothing for a remote control.
There we go.
There we go.
Okay, so we can hear you. This is Brown County case number 520. They're both state of Wisconsin versus Jarvis Rainey. State is here by Deputy District Attorney Mary Carrion-Monreal. Thomas Lincoln is here. Mr. Rainey is hearing CO. Red Granite Correct. We're doing the hearing by CO Conference, Global National and Local Public Health Emergency, requiring limited person appearances, important for everybody's health and safety. We are live streaming on YouTube. There is no one in the gallery. Steve, here.
Judge, I'm sorry. I think we're having some trouble hearing.
I am too. I heard you all through the last court hearing, but you're breaking up throughout this entire one, Judge.
Okay. I think it was because there was some interference in the jail feed, which I then muted.
Okay.
I introduced the. Did you hear that, Attorney Flanagan?
You broke up a little there, but I think you said you introduced the parties, and did I hear that? I heard it broken up, and I knew it was the quote.
Okay, and this actually happened earlier when we had Red Granite, and it seemed to solve the problem when I muted the device. So, Mr. Rainey, I am going to mute the device again, just so you know. Can you give us a thumbs up that you can continue to hear us? And he did give a thumbs up. So we're here on a final conference. I believe the parties contacted the court last week that there would be a request for a new trial date. Is that correct?
Yes, Judge. What happened was I spoke to the state about this case, I believe on Friday, and state asked if we were going to resolve or if we were heading to trial. We were still in a trial posture, but I was going to be speaking to Mr. Rainey. But I did inform the state that about a week ago, my daughter had to go into the hospital and had to have surgery for an injury to her knee, or torn meniscus. And while that wouldn't have presented a problem, normally my wife also suffers from a neurological disorder. So I spend time when I'm not here taking care of her. And my concern was whether or not she'd be able to take care of my daughter. I said I was still going to try to be able to make the trial. That would have been commencing with jury selection tomorrow. But I had left my home and come to the office that Friday, and I didn't know if I was going to be called back. It was suggested that it might be better, even if I'm trying to make the trial and not request an adjournment, it might be better to make the request now, since if I find out that I need to, because my daughter needs me at home, Jarvis would have already been transferred on the order to produce, and then you'd have to quarantine for 14 days, et cetera. So it was suggested, why don't you make a request to adjourn right now? So that's what I did. I was still going to do everything in my power to be able to make the trial tomorrow. But that was the most prudent course of action, and that's what we did, and I thank the court for accommodating.
And I do recall that now that we needed to make a decision last week before he was transported. Otherwise, he would lose his privileges in the prison system. So I am going to grant the adjournment. I guess I didn't ask the state's position, but my understanding that there was no objection from the state.
That's correct. And the victim has indicated there aren't any bad dates in the next few months. So that person understands what's going on.
Okay, thank you. For dates, we're looking at March 24th, a Wednesday, and then every 2 weeks after that, which would be April 7th, April 21st, May 5th.
Let's see. Can you see what's best from a calendar standpoint?
And I guess this would be a good point for Mr. Rainey. Can you just give us another thumbs up if you can continue to hear us? And he did give a thumbs up. Yeah, thank you.
Your Honor, I could do April 7th, but I would have a problem if the court needed us to appear on April 6th because I have an appearance that afternoon in Milwaukee County.
But that is when the jury selection would be April 6th at 1:30.
Yeah, and that's what time I'm in Milwaukee County. As I look at, that's the only week of the weeks the court mentioned that I wouldn't have anything scheduled. In Milwaukee, they held off all trials from, essentially like March all the way through when they started scheduling them again in August. And most of us who practice in Milwaukee County, our calendars are jammed now this spring. So I'm doing the best I can, but that would be the only week that I could from the dates the court suggested. And that's the case of May 5th. 2 weeks after May 5th is the 19th, another jury trial. 2 weeks after that would be June 2nd, another jury trial. I'm sorry. 2 weeks after that, 16th, double booked trial. If we went all the way to June 30th, I do have a trial on the 28th that should be done by, well, no, because you need me on the 29th. 2 weeks after that, the 14th, again, trial. It looks like the next time that there's a free Tuesday, Wednesday, Thursday, Friday would in those 2 week periods the court was saying would be July 28th.
Can you check March 10th? I can't guarantee it would be the top priority though if we put it March 10th.
No, March 10th is booked too. March 10th, 11th, and 12th are booked with several different things, including on a homicide matter.
And then what about February 24th?
Let's see. Scheduled on the 23rd, 24th, 25th. I'm free on the 26th.
Okay. Well, the reopening plan that our county had approved was that we have 8 judges in our county. 4 judges can have trials 1 week. 4 judges can have trials the next week, and then we have to alternate back in every other week. And that's the plan that we had approved by the judge for the judicial district. So I do have to stick to that. So what was the first date that?
July 28th. I'm very sorry. I don't want to upset or inconvenience anyone. As far as Mr. Rainey, he's serving a sentence, so it's not going to. This case is not holding him, so I'm not worried about him. But the state may have concerns. I'm sorry it's that far out, but this pandemic has just screwed up everybody's calendar.
And unfortunately, that's the 1 week that I'm not available either. So we'd be looking at August 11th then.
Which, believe it or not, there's a trial on that day too. There's not on the 25th. This is just going to be a nightmare, not just in this case, Judge. It's going to be a nightmare for the next year and a half for attorneys and judges, especially in Milwaukee, where they've got such a high volume.
So August 25th sounds like the first Wednesday and in the every other week rotation that I have that you're available.
It is, Judge.
Okay. Deputy District Attorney Carrion-Monreal, any comment on the scheduling from your end?
Well, it's very disappointing. I don't think the victim is on at this moment. I know she's attended other hearings. I mean, I guess I don't have a solution given what's been represented. But on behalf of the victim, it's obviously very disappointing.
Yeah, that's exactly 7 months from today. But unfortunately, I don't think that there's any other option because I have to stick to that every other week procedure.
Understood. Thank you.
So we'll pick that date for the jury trial date. I think I'm going to call the case kind of regularly for our status conferences, just to see if there's anything that needs to be addressed. And it should be real easy to coordinate status conferences with Red Granite.
So counsel, the defendant is rejecting the offer that's been submitted?
At this point, that is where we are. Yes, we would have proceeded to trial.
All right, that offer is withdrawn.
Jury selection would be Tuesday, August 24th at 1:30.
At what time, sir?
1:30.
And did we end up on the 25th for the jury?
Yes, August 25th.
Do you do 8:15 or 8:30?
8:30.
Could we have this designated as a number one, if at all possible? I know things can change, but
I don't think that I can. It's the only thing on the calendar right now. That's the only thing I can say for certain. But if there's a case where somebody's in custody and a speedy trial demand applies, then
sure,
that case is going to be a higher priority, unfortunately. If there's
no,
nothing
and I totally understand that could change, but if we could just give this a preferential, if possible, since we're having to put this so far out.
It would, because he's in custody and it's a felony, so the
Okay,
priority
thank
is
you.
fairly high. How about a status conference Tuesday, March 23rd at 3:30? Let's make it 2:30 instead if you're available, Attorney Flanagan. March 23rd at 2:30.
I could do that, yes.
March 23rd at 2:30.
Yes.
Thank you.
And then I guess at this point, if jury instructions, witness list, and verdict forms haven't been filed, then they should be filed by March 23rd then.
Yeah, given where we are, could we have more time than that? We've got a lot of juries we're attending to as well.
That's a good point too. How
Maybe
about
something in July or?
how about due by July 30th?
Thank you.
Anything additional from the state?
No, thank you.
Attorney Flanagan, anything else?
No, sir.
Then bond continues, and that's all for today. Thank you.
Thank you.
Then we can go to our 11 o'clock with Mr. Ramirez, although we're missing his lawyer. So we'll call over to see if we can get his lawyer on. That's
Falta el abogado del señor Ramírez, así que vamos a llamar a ver si podemos conseguir a su abogado en la línea.
Well, we've been unable to get a hold of Attorney Giacone. I think Attorney Malcor said he was double booked. And we can't get a hold of anybody at his office.
No hemos podido comunicarnos con el licenciado Giacone. Alguien nos dijo que tenía el conflicto de horario y no hemos podido comunicarnos tampoco con nadie de su oficina de él.
We can add it to the schedule on Thursday. So we can get a quick turnaround. So that's what I'm leaning towards right now.
Pero
DDA.
podemos agregar este caso a nuestro horario para el jueves para que no tenga que esperar mucho tiempo.
DDA.
I think that, I'm sorry. I think that would be a problem as far as victim notification, Your Honor.
La fiscal menciona que eso sería problemático en cuanto a poder avisar con tiempo a la víctima.
Go ahead and speak. Hola, hola.
Hello, hello.
Pregunto que si tendré otra corte para el jueves.
I'm asking, am I going to have another court date on Thursday?
We're looking at the calendar right now. We're also trying to find a lawyer.
Estamos en estos momentos buscando a su abogado y también viendo nuestro calendario para ver qué otra fecha le podemos dar la cita si es que el abogado no lo localizamos hoy.
Oh, está bien.
Okay.
If we did it next week, but you think that would be sufficient time?
I think if you give us a week. Thank you.
Le pregunta el juez a la fiscal si para la otra semana sería suficiente tiempo para la fiscalía y ella cree que sí.
Está bien.
Okay.
Let's call the case then. This is Brown County case number 20 CF 1349.
Vamos a abrir las actas entonces. Este caso del condado de Brown tiene el número 20 CF 1349.
State of Wisconsin versus Jose Dolores Ramirez.
Es el caso Estado de Wisconsin contra José Dolores Ramírez.
The state is here by Deputy District Attorney Mary Kerrigan-Mayers.
De parte de la Fiscalía está Mary Kerrigan-Mayers.
Mr. Ramirez is appearing by video from the Brown County Jail.
Y comparece por video desde la cárcel del condado de Brown el señor Ramírez.
We are doing the hearing by by video conference because of a global, national, and local public health emergency.
Debido a una emergencia sanitaria global, nacional y local, llevamos a cabo esta audiencia por medio de video.
We are live streaming on YouTube and there is no one in the courtroom gallery.
Transmitimos en vivo por YouTube y no hay nadie presente entre el lugar para el público en la sala del tribunal.
I would note that a plea form was submitted by attorney Jevin Giacone.
Que conste que el licenciado Jevin Giacone entregó a la corte un cuestionario declaratorio.
However, Attorney Giacone does not appear here today.
Sin embargo, el licenciado Giacone no comparece hoy día.
The case was scheduled for 11 o'clock and it is now 11:28.
Esta audiencia estaba programada para las 11 de la mañana, ya son las 11:28.
Attorney Sarah Malcor appeared for him earlier today.
Hoy más temprano compareció por el licenciado Giacone la licenciada Sarah Malcor.
She appeared for him because he had been double booked.
Y ella se presentó en lugar del licenciado Giacone porque según él tenía conflicto de horario.
Since no one is answering the phone at Attorney Giacone's office, I assume that he's still in a different courtroom.
Entonces, como en la oficina del señor Giacone no contesta nadie, me imagino que él estará ocupado ante otro juez en estos momentos.
We will schedule this case for Wednesday, February 3rd at 4 o'clock.
Vamos a programar entonces esta audiencia para el miércoles 3 de febrero a las 4 de la tarde.
There is a prosecutor here on a juvenile hearing at 3:30.
Tenemos fiscal aquí a las 3:30 para un caso de menor de edad.
And that should be sufficient time for the DA's office to accomplish victim notification.
Y debe ser suficiente tiempo para que la oficina de víctimas y testigos se comunique con la víctima.
Is the interpreter going to be available at that time?
Si está disponible la intérprete a esa hora. Your Honor, this interpreter is noting, it looks like I have a 3:45, but I don't know if that's with this branch or not. But I assume if you contact international translators, they will be able to have me or another interpreter, as far as I know.
Okay, thank you.
Entonces la intérprete tiene una cita a las 3:45, pero no sabe en qué sala, pero seguro si se comunica a la oficina de los intérpretes podrán tenerle a alguien.
And I forgot your appearance in the first place. It's certified Spanish interpreter Susan Rascon.
Y se me olvidó mencionar en primer lugar que hoy comparece la intérprete certificada Susan Rascon.
Have you been sworn yet today?
Y que si la intérprete ya prestó juramento el día de hoy. Yes, Your Honor, I have.
Okay, thank you. Then you'll
La
continue.
intérprete ya prestó juramento hoy.
Does the state have any additional comment on anything?
No, thank you.
Otro comentario de la fiscal, no, gracias.
So, Mr. Ramirez, unfortunately, we could not call your case here today because your lawyer isn't present, but we have it scheduled for next week.
Señor Ramírez, lamentablemente no pudimos atender su caso hoy como su abogado no está presente, pero le programamos ya la cita para la semana que viene.
¿Qué día sería?
What day would that be?
Wednesday, February 3rd at 4 o'clock.
Será el miércoles 3 de febrero a las 4 de la tarde.
And then bond continues, and that's all for today. Thank you.
Mientras tanto, sigue vigente su misma fianza y será todo por hoy.
No te escuché. ¿A qué hora sería la corte?
I couldn't hear you. What time is the court date?
Wednesday, February 3rd at 4 o'clock.
Es a las 4 de la tarde, el otro miércoles 3 de febrero.
Ok, está bien. Gracias.
Okay, fine. Thank you.
At future hearings, if he cannot hear us at any point, he should speak up right away.
Y señor Ramírez, en las audiencias futuras, si en cualquier momento no nos escucha bien, que nos avise de inmediato, por favor.
Está bien.
Okay,
Gracias.
thank you.
Then that's all for Mr. Ramirez's hearing.
Entonces se levanta la sesión y se cierran las actas en el caso del señor Ramírez.
Ok, gracias.
Okay.
And then we have the 11:30 case with Mr. Manzone.
Gracias.
We are missing Attorney Martin, though. So we'll see if we can find Attorney Martin.
Tenemos ahora el caso del señor Monzón, pero falta el licenciado Martin. Lo vamos a buscar.
Attorney Martin popped into the courtroom and said he's gonna step out into the hallway and log into the Zoom right now.
El licenciado Martin acaba de entrar aquí en la sala y dijo que va a salir al pasillo para conectarse así por Zoom.
This is Brown County case numbers 19 CT 1336,
Son los casos del condado de Brown, 19 CT 1336,
20 CT 605,
además del 20 CT 605
20 CM 1285,
y el 20 CM 1285,
20 CM 1286,
el 20 CM 1286,
they are all state of Wisconsin versus Romario, Manzone.
son los casos Estado de Wisconsin contra Romario e Manzone.
Mr. Manzone appears by video.
Comparece por video el señor Manzone.
Deputy District Attorney Mary Kerrigan-Mayers appears, as well as Attorney Kevin Martin.
Y comparecen la fiscal Mary Kerrigan-Mayers, además del licenciado Kevin Martin.
We are doing the hearing by video conference because of a global, national, and local public health emergency.
Debido a una emergencia sanitaria global, nacional y local, llevamos a cabo por video esta audiencia.
We are live streaming on YouTube. There is no one in the courtroom gallery.
Transmitimos en vivo por YouTube y no hay nadie presente en el lugar para el público en la sala del tribunal.
Certified Spanish interpreter Susan Rascone is also present. She has been previously sworn and will continue to be sworn.
Está presente la intérprete certificada Susan Rascón, que ya prestó juramento y sigue bajo juramento.
We're actually going to go off the record for a moment while I address another case for a second.
Vamos a hacer una pausa en esta audiencia para yo hablar un momento sobre otro caso diferente.
Attorney Giacone, we actually scheduled Mr. Ramirez's case for next week, Wednesday, February 3rd at 4 o'clock.
Okay, and I apologize for the delay. I assume Mr. Mouse as well.
Mr. Mouse, I don't know what date we picked for him. I don't remember that one off the top of my head.
Okay, I'll check it. That was my bad. We were doing some trial prep in branch 7 that took a lot longer than I thought. Thank you.
So I think that's it for you then.
Okay, appreciate it. Thanks.
Okay, thanks. We are back on the record for Mr. Manzone.
Volvemos a atender el caso del señor Manzone.
Attorney Martin, what is our status here today?
Licenciado Martin, ¿cuál es el estado del caso hoy?
Thank you, Your Honor. We just received a global offer this morning, and so I was hoping to set this out for a plea and sentencing date for in March. Thank you.
Gracias, su señoría. Apenas esta mañana recibimos una oferta global para resolver todos los casos. Si nos puede fijar fecha para declaración ante el cargo e imposición de la pena para el mes de marzo. Gracias.
How about Friday, March 5th at 3:30.
¿Qué tal el viernes 5 de marzo a las 3:30?
Sorry, Your Honor, I'm not available. Could you possibly have another date further out?
Disculpe, si nos lo puede aplazar un poco más, no estoy disponible en esa fecha.
Friday, March 12th at 10 o'clock.
El viernes 12 de marzo a las 10 de la mañana.
Yes, Friday, March 12th at 10 o'clock.
El viernes 12 de marzo a las 10 de la mañana, sí.
Friday, March 12th at 10 o'clock. Mr. Manzone, did you hear that date and time?
Entonces, el viernes 12 de marzo a las 10 de la mañana, ¿escuchó la fecha y la hora, señor Monzón?
Viernes 12 de marzo.
Friday, March 12th.
Yes, at 10 o'clock.
Sí, a las 10 de la mañana.
Sí, escuché perfecto, gracias.
I heard perfectly, thank you.
Anything additional from the state?
No, thank you.
Algo más de la fiscal, no, gracias.
Bond continues. That's all for today. Thank you.
Mientras tanto, sigue vigente su misma fianza y será todo por hoy. Gracias.
Sí, está bien, gracias.
Okay, thank you.
And that's the end of the morning calendar.